The Supreme Court of India has denied bail to Umar Khalid and Sharjeel Imam in the ongoing 2020 Northeast Delhi riots case under the stringent UAPA law. In fact, the bench held that the material placed on record prima facie suggested a central role for both in the alleged larger conspiracy, meaning the statutory conditions for bail were not really met at this stage. At the same time, the court granted bail to 5 other co-accused, Gulfisha Fatima, Miran Haider, Shifa-ur-Rahman, Mohammad Salim Khan and Shadab Ahmed on the basis that their roles have appeared less central and thus warranted conditional release. But the court also clarified that delay in trial alone is not sufficient to grant bail under UAPA. It emphasized that each bail plea must be considered on its own merits. So the big question we asked today, how can a democracy protect national security without turning dissent into punishment? A short while ago, I spoke to former Solicitor General of India, Harish Salve, and this is what he said. Former Solicitor General of India, Harish Salve, joins us now. Thank you, Mr. Salve, for your time. How do you look at the Supreme Court's judgment today? If bail is the rule and jail is the exception, how does the Supreme Court justify years of incarceration under UAPA when the trial hasn't even begun?
You confuse so many different idioms, but not your fault, you're not a lawyer. Jail is the exception, bail is the rule in normal law. We have statutory exceptions to this principle. In the old IPC, section 302, jail was the rule, bail was the exception, because the accused had to establish that there was no case. It was not for the prosecution to establish that the accused had to be kept inside. So these are good general catchphrases, but they don't set out the law accurately. So this is what happens. The UAPA has provisions, the drug law, the anti-drug law has provisions like that. There are a number of statutes in which bail is not the rule. Bail is the exception, jail is the rule, if one may put it in a catchphrase. So the burden is very high, and accused has to show that there is no case made. That is a high bar. There is an entirely independent ground that if a trial is being delayed, the bail should normally be granted.
Okay.
The purpose of incarceration, pre-trial incarceration, partly is preventive. If there is a fear or concern that if bail is granted, there will be witness tampering, there will be interference with the course, or the events may repeat themselves. And that is where the balancing comes in. Now, undoubtedly, unconscionable delay in commencement or prosecution of a trial is a very strong ground, but it's quite another matter where 3 courts have now found concurrently that the delay was at the door of as much as of the accused. And many times accused are in no tearing hurry to get on with the trial for good reason. And these are what we call in the criminal court, these are forensic ploys. Many times you don't want to go on with framing the charges, you want to see what happens, etc., etc. So if those are the things which are in play and which have caused the delay, then this principle of prolonged incarceration doesn't apply. See, the state is under a duty to have quick, efficient trials. Forget this case. In any case, criminal trials should not be kept hanging because there is a mental price you pay for a criminal case pending against you. Yeah. So speedy justice is a rule under Article 21, but many times the accused, so if there is absence, if there is no judge present, if the judge has gone missing, if the prosecution is not showing up, those are cases of extended incarceration. Here where the fault on balance lies more on the, as much if not more on the accused as it does on the prosecution. Then that principle doesn't come into play. So that's why I said you mixed up 2 idioms.
Okay.
Bail, not jail is one.
Okay, so that was a good clarification. But Mr. Salve, in the last many years, we've seen that Supreme Court has often nudged the government to do away with the colonial sedition law, which some people are now saying is back in disguise in the form of the new criminal laws. Courts have been ruling out that even shouting certain slogans, I don't want to say those slogans now, is not an act against the country. So how does any speech attract UAPA to keep individuals in jail for a long time?
2 short answers. Context matters. societal context matters. The time of the time it. You see, there was a strong argument against death penalty for abolition. There was a strong pro-abolition argument. With the advent of terrorism, that argument has fallen away.
Yes.
So you cannot view these things divorced from the context of the times. Secondly, I have only read the Supreme Court judgment cursorily. I have not analyzed it in great detail. I know nothing about this case before I read this judgment. The court has said that it is not just a speech. It is a course of conduct. The speeches were a part of the overall course of conduct. And the course of conduct was clearly within the meaning of the unlawful acts. So sedition is a side issue here.
Right.
It's terrorism within the meaning of the unlawful act, and the Supreme Court has construed the phrase by any other means. So the whole discussion is very different. I'm surprised who's talking about sedition here.
Right. Sir, I know you've touched upon this. The 2020 Delhi riots have been the worst form of violence at the capital witnessed since 1984 anti-Sikh riots. In both these instances, in both these cases, we did see that police action came under a lot of scrutiny. But the larger criticism is that in the 2020 Delhi riots cases, there was an impression that accountability focused a lot on intent and speeches. What kind of lessons do you think the state, agencies and administration need to learn from this episode?
In 1984, was there any action? I'm not aware of any action. Prior to certain actions, the only time actually, first time where riots have been prosecuted was the Gujarat case.
Yeah.
Post-Gujarat riots. And of course, the narrative is nobody prosecuted in Gujarat, but the only time where prosecutions have been laid is, look at Bombay.
Yeah.
1992 riots, one of the worst, 93 January riots, one of the worst ever in the history of India. Are you aware of any prosecutions?
No.
I'm not. In fact, there was one prosecution where somebody was caught with a automatic rifle, and even that was withdrawn.
Yes.
So, when people give lectures on prosecution, etc., it's no use. Let's talk about this.
Yeah.
The FIR was registered in Jan 2020. I think the first charge sheet was filed pretty early by November 2020. So I think it was all fairly quick. And it was, the court has said it's a complex investigation. See, these investigations which are trying to unravel, look at what's going on in our neighborhood. Look what's going on in Bangladesh. Look at what happened a while ago in Burma. And look at what happened in Sri Lanka. Look at what happened in Nepal. There are people who want that playbook to play in India. Now, you may strongly feel that a particular government should go. You may strongly feel the system of order is wrong, etc. But laws are made to protect society. And if you cross those lines, you pay the price.
Right. Sir, just an offshoot from my earlier question, how fair can riot trials in India truly be? Because, I've seen both sides holding deeply polarized views. So in that case, how can courts balance the demand of security? It's just not a demand, it's a responsibility, duty of the state with principles of justice.
Fortunately for us, the court doesn't have to deal with the kind of debates you see on TV channels. The court is concerned with evidence. The law is clear. The interpretation has been given by any other purpose. Supreme Court has said that's an unlawful activity. They have said prima facie, if all this is correct, then this would be unlawful activity. And if the evidence is there, the conviction happens. Thereafter, you can continue having debates on TV whether India has fair laws or unfair laws.
Right.
But today one can debate anything. There are people who justify going into another country, grabbing their president, putting him in handcuffs and bringing him in. All sorts of things are going on. So we don't want to, those are academic debates we can have on different fora, on TV and in speeches and saying India has become illiberal, etc., etc. I want my India to be safe. I want my India not to suffer. We are an island of democracy today. We have failed states all around us. We don't want to go down that road.
Absolutely. One of my last questions to you, Mr. Salve, a few days ago, we also saw the new mayor of New York, Zoran Mamdani, writing to Umar Khalid saying that he remembers him. There were also other congressmen who talked about a speedy trial in this case. Do these international incidents, developments also have any impact on Indian judicial processes?
So I don't think so. I think Mr. Mamdani has his plate quite full trying to fix what's gone wrong with minorities in his own speeches where minorities are treated appallingly in his country, right? I think they should all focus on that.
Okay. And one last
We have
question.
more, our courts and our citizenry and our media, all of us are strong enough to keep India's democracy ticking. We don't need Americans and their system of extradition, their system of trial, their system of police atrocities. I mean, we can also go on and on about them, but why? You be happy in your country, let me be happy in mine.
Right. Last question.
And Mr. Mamdani, best of luck dealing with New York's discrimination.
Okay. So you think no impact of that, but even on public pressure?
Irrelevant. They are completely irrelevant, and I think they should be treated with the contempt they deserve.
Okay. And so the timeline of 1 year that has been set for the accused to appeal, is that usual?
Not appeal. It happened many times. If you are sitting in a court, you know this as a practicing lawyer, sitting in a court, so many times the court says too early, come back after 6 months, come back. It's not time.
Yeah.
It is, you're giving 1 more year. If in that time also, now with this crack of the whip by the Supreme Court saying stop procrastination, do not allow the accused to play these games, trial court, please crack on. It's a message to the trial court that within 1 year's time, you should have crossed at least all the protected witnesses. Then the court will see what is the evidence which has come on record, how far has it got. If it is satisfied that it has got to a place and there's even stronger evidence, it may not grant him bail. If it feels that it is now safe to grant. See, this is not punitive incarceration. So if you feel now there's no damage he can do, even if he's let out, he'll be let out.
Right. Thank you, Mr. Salve, for your time and for speaking to NDTV. Thank you, sir. Now, for the other side, Ashwini Kumar, former law minister, joins us now. Thank you, Mr. Kumar, for speaking to NDTV. You heard Mr. Salve. Now, when the case is all about an alleged planned role in Delhi riots, can a long time in jail alone be enough to justify bail under an anti-terror law? By giving bail to some accused and not to the others, many feel that the court has shown that each case is judged on its own facts and not as a group, and that many feel is a good thing.
Well, the Supreme Court, in a series of judgments, have said that the accused have a fundamental right to speedy trial, and long incarceration without conviction is in itself a very major consideration in the exercise of judicial discretion to grant or not to grant bail. And this principle must hold true in all statutory instances, whether it is UAPA or PMLA. There have been a series of judgments in special statutory enactments also, where the court has said that Article 21 must have primacy over all statutory provisions when it comes to the liberty and dignity and privacy and reputation of an individual. And that has been the jurisprudence of this country, and that is the core of Indian democratic ethos. The fundamental aspect that you need to consider in this case is, why could the prosecution not bring home the guilt of the accused for 5 long years? Leave aside bringing home the guilt of the accused, not even begin the trial for 5 years. And is there a recompense for the loss of liberty of an individual who is merely suspected of a crime but is eventually acquitted? Who will be responsible for that loss of freedom? Please remember that in all the jurisprudential debates, whether it relates to a criminal statute or whether it relates to any other criminal provision,
Right.
One fundamental aspect can never be lost sight of. Judiciary, particularly the constitutional courts, are meant to mediate between the citizen and the state when it comes to matters of liberty and fundamental rights. Who is responsible for bringing home the guilt of the accused? Beyond doubt, it is the prosecution. If the prosecution has not been able to do so for 5.5 long years, must an accused suffer? That's the principal question. Now, what is surprising in this otherwise very eloquently written judgment is the court's observation that it is not persuaded that the long detention has crossed the threshold of constitutional impermissibility. These are the words from the judgment. Now, pray, ask the court, where is the threshold of constitutional permissibility laid down? It is laid down in the exercise of their discretion and by the exercise of their discretion. And that is why now the court has said, we give you 1 year to expeditiously try the case, and then liberty is granted to the accused to apply for the bail.
Okay.
Now, this is nothing but an exercise of discretion. I ask myself the question, why could the court not have said that 5 years long incarceration without bringing home the guilt of the accused is good enough? That's the threshold, and we will not allow further detention of these people without even a trial, leave aside conviction.
Right.
That should have been, in my respectful submission, and I say so with the utmost deference to the highest constitutional court, for which I have great respect, that should have been the discretion that the court ought to have exercised. Therefore, one other point which I want to make, please remember, India is no banana republic. India is a sovereign democratic country of 140 billion people. The question remains, can 2, 4, 5, 10 people accused of harboring designs to disrupt the unity of India challenge the constitutional conscience of the country? The question is, right now, with all the offenses arraigned against them, they are merely accused.
Right.
Nothing has even begun.
Right.
Therefore, they should get the benefit of the constitutional conscience of the Constitution.
Yes, a valid point here, but you also heard Mrs. Salve, and there are many experts who believe that in cases linked to national security, and this is one such case, it is reasonable for law to put public safety over personal liberties, at least till the trial is completed. So, I mean, I know you're talking about a balance here, you're talking about something that needs to be done, but you just heard Mr. Salve who says that, India is an island of democracy and there are countries going completely berserk with protests all around us. So this is about national safety, national security and keeping our citizens safe. So how will you even counter an argument like that?
Well, I don't comment on individuals. I have my own views, and my view is absolutely clear. The routine invocation of national security can never be a justification in a true democracy to deny people their freedoms. Where is the democracy without the freedoms of the citizens? The state exists for the citizen. The citizen does not exist for the state. It is the citizen and the individuals who have consented to confer authority on the state in the interest of both collective security and collective good of the people. But if in the process the state itself becomes oblivious to the need to safeguard and protect and zealously preserve the liberties of individuals, then I think there is a question mark on democracy itself. Substantive democracy is about rights. It is about fundamental rights. It cannot be about a criminal justice system where the process itself becomes the punishment. Please ask yourself this question, which I do all the time. Is there a recompense for the 5 years of lost liberty of these people in case they are acquitted? There isn't. So if there is no recompense for an injury, it is better to minimize that injury on your own citizens rather than to perpetuate that injury. So why is it that a citizen has to knock at every single door, at every level of the judicial process for just the freedom to be? Yes, I can understand heinous crimes of any nature must be punished. There is logic in the retribution system of criminal law, but it is only after the guilt is established, not before. What happens to the presumption of innocence? What happens to the principle that bail is the rule and jail is an exception? What happens to the sacrosanct principle of constitutional law in this country, that Article 21 is at the pinnacle in the hierarchy of fundamental rights, and all statutory provisions have to be interpreted to be in consonance with the spirit and letter of Article 21. This is the judgments of the Supreme Court in several cases.
Right.
This particular judgment seems to be diluting that principle. And that is my difficulty with this judgment.
Absolutely. Mr. Kumar, thank you so much for making those points. Former Law Minister Ashwini Kumar there. Thank you so much for joining us. We're also joined by Arfa Khanum. She's a journalist and a writer. We also have Tuhin Sinha of the BJP. Thank you both of you for being part of this broadcast. Tuhin, to you first. You heard both sides. Critics have been saying that the UAPA, a law today, is being used as an investigative tool to deny bail. Rather, it's being used as an exceptional law to deal with, with cases that are being seen as terror cases. Delhi riots have been worse since 1984. The police action is facing sharp criticism. What have we to learn from this entire episode?
Good evening, Vasudha. Good evening, everybody. I think it's a very calibrated, very cogent, very fine judgment. And anybody who still backs, the likes of Umar Khalid after that, obviously is a self-professed urban Naxal. The point is just two sentences, just 2 points of the judgment sum up the core, the core essence of the judgment. One, where Section 15 of UAPA, is defining a terrorist act apart from death or destruction. The provision encompasses act that disrupt services and threat to the economy. So you can, when I finish, you can just play out the speeches of Sharjeel Imam and whether they amounted to disrupting the economy and disrupting the integrity of the country or not. Number two, it becomes necessary to examine each appeal independently. The record discloses that all the appellants do not stand on equal footing and on culpability, and that is where the prime culprits, which are the two men, have been given a greater hierarchy in that entire process. Now there are three takeaways from this whole thing. Number one, it reiterates India's judicial integrity. No woke alliance, no global woke alliance can intimidate us. The likes of Mamdani, who were writing letters, I don't know for what, casting aspersions on judicial system. I think it's a message to them. It's a message to the Islamist ecosystem in India. And of course, it's a message to the Congress party, because three top lawyers defending the culprits belong to the Congress party: Kapil Sibal, Abhishek Manu Singhvi, and Salman Khurshid. And I think today Congress party, and especially Rahul Gandhi, owes an apology to the country for the 50 deaths which resulted due to the Delhi riots. They could have been stopped.
Right. Arfa, under India's terror law, I know that both sides have very powerful arguments in this, but if the court sees early material suggesting a key role of a larger plot, it gets bound by law to refuse bail at this stage. So what do we have a problem with? Is it the law or is it the process?
Vasudha, first of all, it is really a dark day for Indian democracy, and I feel disappointed as a citizen who still believes that India runs on rule of law. I believe there can be no democracy without the right to liberty, the fundamental right that has been guaranteed by the Constitution of India, and leave aside, the largest democracy of the world that we are as India. But even in a small country, or even in any decent society or democracy, you cannot take away anyone's right to basic liberty and freedom. Now tell me, 5 years and 10 months in jail without an iota of evidence or witnesses being produced in the court of law. The case has not begun. Now tell me, your BJP spokesperson was saying that how it is a conspiracy, and the message, I think the only message we are trying to send to the Muslim community, which has lived on the margins of Indian democracy, which has been at the receiving end of every politics and political action and the policies of Modi government, that if you challenge the mighty government, if you challenge the so-called, strong prime minister and any policy that he makes, and if you try to assert your right to basic citizenship, if you assert your rights as a citizen, then you will be punished. I think Umar Khalid and Sharjeel Imam, by detaining them in jail for more than 5 years, this is the message. Are you trying to send this message to the young Muslims that they are not equal citizens? They cannot disagree with the government. There is no right to dissent in this country. There is no right to free speech in this country. That you will be now remain in jail on grounds. I mean, if 5 years is not the red line, I am so sorry to say, when exactly are you going to really stop at. If
But Arfa,
5 years is
but
not
Arfa, this
enough,
matter
it's going
was
to
in
be
the
almost
court.
6
Are you
years. And
suggesting
also
that
another,
if today...
Vasudha, another very important thing.
Yeah, please finish your point.
Yeah, there's a very important thing I want to say, Vasudha, that tomorrow, when the trial begins and the court finds out that these gentlemen, Sharjeel and Umar, were innocent, who is going to really return those 5 prime years of their youth? You know, Sharjeel and both Umar, they both are, intellectuals. The courts themselves have said that they are really clever gentlemen, clever men. And who is going to return? Who's going to really return the prime of their youth to them? They would be,
But Arfa, are you
suggesting
that the processes that we saw today in the court, the judicial processes, these decisions are not free from public pressure or even political pressure? Is that what what you're suggesting?
I mean, I'm not saying that the courts are working under pressure. I'm not trying to question the judicial wisdom. What I'm trying to question here is that this is a complete failure of the state. The state has failed in starting the trial, filing the charge sheet on time and, giving enough evidence. I mean, only when the trial starts, then the evidence and the witnesses will be produced in court. So it may not be the failure of the court. I am not questioning their judgment. What I'm trying to question is the intention and the failure of the state in starting this whole case. I'm saying if Umar Khalid is guilty, अगर उमर खालिद ने कोई गलती की है आप फांसी पे चढ़ा दीजिए उमर खालिद को शर्जील इमाम को but at least let the case begin.
Okay,
that's the only thing I want to say here, and I am saying here as somebody who covered the NTCA NRC protest that this sends the chilling message down the spine of everyone who was even remotely associated with the CA NRC movement, that if you try to assert your right as a citizen of India, this is the fate that you are going to meet.
Okay,
you are essentially
that's an important point, and also the crux of the critiques argument, but also this question that Arfa is asking also leads to another question, because when trials get delayed endlessly, evidence becomes largely circumstantial.
No,
which means
Vasudha,
there could be charge sheets running into thousands of pages. Then it's very realistic that the accused practically stands. They may not really stand a chance.
No, I think
right?
Vasudha, you should have called out the falsehood of my counterpart over here. But let me call out the falsehood over here. If the trial is delayed, it is not because of the prosecution. It is because of the lawyers of the accused who have been repeatedly seeking adjournments. And let me over here. Let me just read out one paragraph which will validate my point. This is from the judgment passed in the High Court in the Taslim Ahmed case, accused in Delhi riots. Now, I'm just reading one paragraph which will prove the point why the trial has been delayed. A bare perusal of the order sheets clearly indicate that the learned counsel for the accused have taken many adjournments during the course of the arguments on charge. The order sheets show that the learned counsel for the accused were not ready to argue the matter on charge, thereby protracting the proceedings. And this thing has been called out at least from two or
the former Chief Justice of India has also spoken on this, Arfa. What would your remarks be? Because
that why did the police took so long in filing a charge sheet? I mean, the law demands that it should be filed within the period of 6 months. Tell me what exactly, if there are really solid evidence against Umar Khalid and Sharjeel Imam and rest of the people who are accused in the case. And I want to remind you, Scroll did a fantastic report when they said the whole case is not starting, it's not beginning. The trial, the police and the state is hesitant in starting the trial because the whole case stands on sand. They literally, the so-called protected witnesses, they literally interviewed them, and many of them did not even know who the accused were. I would urge the BJP spokesperson, if he really believes in equality and fairness and rule of law, to please...
But Arfa, the fact that two of them did not get bail, the others did, would make any common person think that this is happening too repeatedly to even think that there could be some discrimination or bias against these two people. Tuhin Sinha.
I just have one point. If the charge sheet has got delayed, it's an exceptional case. Probably, it would not get delayed now that BNS has been implemented. So, there are stricter norms now. It has got delayed. That's another thing. But point is, when Arfa says, if they are guilty, you hang them, I just want her to comment on the videos which are playing out of these two young men. Does she condone those thoughts? Does she condone, one person saying that the chicken neck should be broken away because, there is a Muslim majority that would help us break the chicken neck away? Does she condone that, India has forcibly occupied Kashmir? I think she also needs to take a stand. If these things are not condemnable, if these things should not be censured, if these things should not be punished, then what should be the punishment criteria?
Arfa?
No, I don't have to agree with everything that Sharjeel and Umar have said in order to defend their basic right to liberty. I do not have to agree with everything they said. I think that was very stupid of them, stupid of Sharjeel to have said this. I don't agree with anything he said in that statement, but we can debate over this. He's a young man. He tried to say something. If this is illegal, he should be punished. I don't have to agree with everything they say, but is it terrorism? Does it, only the lawyers can tell you, only the people who really know. I am not an expert on law, but at least I can tell you that I don't agree, and majority of the Muslims and even people who are non-Muslims do not agree with what he said. It's a stupid statement made by a young man. He might regret after making that statement, but is it terrorism? Does the court of law define it as terrorism?
Right.
Does he deserve to land in jail without trial for more than 5 years for making that statement? That's my question. And also, I want to remind you, Tuhin, that when this whole riots, the Delhi riots broke out, Sharjeel was already in jail. Yeah. And what we are discussing right now is not the statement that Sharjeel had made. What we are discussing the FIR 59, which is related to Delhi riots.
Right. Tuhin Sinha.
Well, the statements are just the icing on the cake. We know for a fact the kind of person that he is. Fact is...
No, because she's not agreeing with the statement. She's saying that it's a stupid statement, but does it deserve, does it make somebody deserve to be in jail for almost 5 years without trial? That's the larger question.
The statement merely...
Or will it be defined as terrorism? Will it be defined as terrorism?
The statement merely gives an idea of his mindset. Fact is that there is concrete evidence of, the involvement, of the deep involvement of both of them by way of inflammatory speeches, number one, and mobilization efforts in being the intellectual architects of the riots, Delhi riots, which were timed at a time to bring international disrepute to India, and which eventually led to the merciless death of 50 Hindus. I think that is the grave charge over here, if Arfa does not remember that.
Arfa, the larger question is also a very mass-driven argument, and it's also an important thing that national safety, security is the duty of the state, and they would want to keep all external anti-national forces at bay. How can you even respond to that kind of... Because, the legal processes are on one side. What about the larger mass sentiment, the public pressure, and the fact that these two men have been repeatedly denied bail for a long time, and the fact that they've made speeches which all of us agree have been extremely problematic?
Vasudha, I'm sorry to inform your viewers that, neither of you have really described that during Delhi riots, out of the 52 people who were killed, 2/3 of them were Muslims. There were mosques which were burnt, there were mazars which were burnt, there were Muslim businesses which got affected. Muslims got largely affected and impacted, and their houses were burnt, their shops were burnt, and now only Muslims are being accused in initiating and being key conspirators in this case. Tell me, even if you don't know any law, I am not an expert on law, but at least I have common sense, and I urge your viewer to judge by themselves.
Okay. That's important. Tuhin Sinha, the victims of Delhi riots were not just Hindus, Muslims also died, Muslims also suffered. So why make it just about identity?
2/3.
I would not, let us not get into, I think riots are more about numbers. It's about, the way you have impacted the psyche of an entire city. But fact is that, if there was retaliation from Hindus, we all know what happened on the first, second and third days. And, in as unfortunate as it was, from the fourth day onwards, there
that would also raise questions on policing, right?
Well, absolutely. Absolutely, nobody can deny the accountability of the Delhi police. I only wish there were, there was somebody from the Congress also on your show, because the way three senior leaders, like I mentioned, of the Congress party have been defending these two culprits, it really raises serious question marks over the intent of the Congress party when it comes to national security. And I'm, there are reasons obviously why the Congress party must have chickened out and not been a part of this debate.
Right. Arfa, it's all about national security, and it's important that we safeguard that at the cost of everything else.
I am just saying, Vasudha, that the demand of our common sense, and that's why I'm urging not the BJP spokesperson, but your viewers, and I'm assuming that they are the citizens who want to hold the government to account, first of all, by delaying filing the charge sheet. So this is the failure of the state. Number two, I'm saying it fails common sense that in a riot where 2/3 of the numbers of the people who were victim of this riots were Muslims, and now the key conspirators are also Muslim. Now imagine this gentleman who's now a minister in Delhi government. He was the one who made on camera, he made inflammatory speeches. Him and his team turned the whole, the protest site into, the rioting actually began on the protest site. Nothing happened to him. He's now this honorable minister. He's not being brought
I don't think the protests were completely peaceful, because all of us do remember that the protests were not completely peaceful. Tuhin Sinha.
Sadly, my counterpart,
the rioting, Vasudha, only started when this gentleman...
My counterpart sadly exemplifies woke hypocrisy. When you criticize the state for the delay in filing the charge sheet, to retain your own moral uprightness, you should first, call out the machinations, the vile intent of Sharjeel Imam and Khalid Umar. I never see you do that. There are so often you have called out Hindu symbolisms being used in Indian Parliament, but when a Mamdani takes his oath on Quran, you call it freedom of speech. So I think, the woke ecosystem needs to get out of its hypocrisy before we take them seriously on their criticism of the lapses in the case. It's as simple as that.
Alpha, very quickly respond to that. Are the left liberals selective in their use of symbolism?
How funny it is, Vasudha. It's funny, Vasudha, that we were discussing the Delhi riot case, we were discussing Umar Khalid and Sharjeel Imam and the NTCA and RC protest, and your friend from the BJP brings in New York. What I'm trying to say here is that not just Mamdani
we're discussing hypocrisy
on Quran, but every single I'm saying majority of the Hindu senators and representatives in the United States, they have also taken oath on Gita or whichever other book they believed in. So I am not against people following their religion. I'm only against people discriminating, the political leaders discriminating people based on the religion. I am not against Mr. Modi or Mr. Yogi Adityanath or our friend Tuhin in following their religion. We can do whatever we want to do, and this whole, the freedom of religion is also given to us by Indian Constitution, and there, in New York by the Constitution of the United States.
Okay.
So I see nothing
quick
wrong.
word, Tuhin, closing remarks from you, because the Supreme Court has managed to keep the country safe while maybe trying to strike the balance, and at least also leading to a little bit of disappointment when it comes to personal liberties. Or are you completely happy with what the Supreme Court has said today?
No, it's a benchmark decision. I think it's a decision which will be referred to in a very long time on issues of national security. And of course, it's a very sad day for the global woke alliance, those who thought that international pressure could intimidate our judiciary. I think hats off to our judiciary for taking a very calibrated, very cogent view on the entire thing.
Okay, thank you so much, both of you, for joining me on this broadcast. Tuhin Sinha of the BJP and Arfa Khanum Sherwani, journalist there. Thank you, both of you, for joining me on the broadcast.